at the amendments and ordinances. The first of the amendments is by the Government of Maharashtra to the Labour Fund Act 2024, by which the contribution is being made 25 rupees by the employee and 3 times the same by the employer at rupees 75. The next amendment again from Maharashtra, but it's a very small one, where they have extended the time for filing of the returns under the Professional Tax Act by a month because of technical difficulties. In the circulars and notifications, under paragraph 68J of the EPF scheme, subscribers are allowed to take an advance for their own or dependents' medical expenses. This has been enhanced from rupees 50,000 to rupees 1 lakh. The Delhi Construction and Workers Welfare Cess Act 1996, the Delhi government has taken a policy decision to receive all the cess only through online portals and no more in any other method. So every payment will only be through the online portal. Under the Right to Persons with Disability Act 2016, there is a percentage of reservation meant even for in apprentices training. In this regard, a notification has been issued where the training quota has been increased from 3% to 4%, and the disabilities has as well been increased, and who comes within the ambit has also been brought in by a notification by the government. Moving to our next segment, the quiz segment. The question is, can an employee waive the right to receive minimum bonus under the Payment of Bonus Act? We would have the answers at the end of the program. We request you to key in your answers in the chat box. In the global segment, we look at a law that New York has brought in. So where employees are at times, even the employer requires employees to go on the social media, create new accounts and use it. And sometimes the employees' existing social media accounts they use to promote the businesses of the employer. The new law that they have brought in is where if it is an existing account of an employee, that the employer cannot seek access to the said social media accounts if they are personal accounts of the employer. So therefore, unless the employee has been informed earlier that he has to create a social media account and the employer will have access to it, the employer cannot have access to social media accounts of employees. The next is a case from France where one employee sends email to another colleague with certain racial comments in it, and he was dismissed for it by the employer. The courts overturned it, saying that it's 2 private messages. Yes, he has used the official email given by the employer, but that would not mean that it is a exchange, and where it is a personal and confidential exchange between 2 employees, that cannot be looked into by the employer and for dismissing an employee. So it's a very unique proposition that the court has come about, saying that even though it's an official email addresses that is being used in the communications is private in nature, and therefore you cannot use that to dismiss an employee. There's much spoken about the codes and about the provisions of the interstate migrant under the codes of what is to be given. But many are not even aware that even under the current Interstate Migrant Act, there is a provision for displacement allowance and journey allowance. A one-time payment of 50% contributions to be made by the contractor to the interstate migrant workmen. Similarly, journey allowances has to also be paid. If they fail to pay, the ISM can ask for it from the principal as well. Unfortunately, it is not known to many, and therefore we thought we will share about it. This is a case where arriving from the Bombay High Court. The employee joins in 91 and gets dismissed in 1995. And ultimately, the dismissal is challenged before the by raising an industrial dispute. The labor court awards reinstatement of the employee with 50% back wages, more because there is no inquiry that is being conducted. Ultimately, the award is slightly modified, giving compensation by the court, but the crux is not holding domestic inquiry was put against the management in this. Why we are stressing on this is many are under the impression that only a shop floor worker comes within the definition of a workman. The standing orders apply only to them. For instance, staff, lower end staff who don't perform much of any managerial or supervisory work, they are not considered as workmen and inquiry is not held. This appears to be one such case. It is only due to that we put this case law to impress upon our viewers that even if a person is called as a staff, not a workman per se, working in a shop floor, you would need to follow certain procedures. You cannot dismiss them without holding a domestic inquiry. This case arises, it's a banking case. The crux again here is about the regulations of the bank cannot overrule the Payment of Gratuity Act. The Payment of Gratuity Act provides for forfeiture of gratuity only in certain circumstances. In this case, the bank had not quantified the loss that it had suffered owing to the conduct of the employee. Therefore, though lower courts had given conflicting judgments, the Supreme Court ultimately said that the loss has not been quantified and therefore forfeiture would not arise. And similarly, it's also directed the bank to pay provident fund. Of course, it is provident fund under the banking system is completely different. But here again, it found that there was certain irregularities on the procedural lapses on part of the bank and directed payments. So this judgment is more for the proposition that unless you quantify a loss, you would not be able to forfeit the gratuity. We have been informed that the Karnataka High Court has struck down the pension IPF scheme relating to international workers. We are awaiting the judgment. We shall touch upon it in the next month's update. We have been looking on the concept of retrenchment over the last few months. This will be the last of the months where we will be looking into retrenchment as a topic in our knowledge corner. Here we start with a case where the employee was engaged based on a project. So project-based engagement. The employment was coterminous with the project. So when a project is awarded, the company appoints him, terminates him when the project is over. Thereafter, again, it takes him when a new project comes in. The employee on termination of the last projects came up with the contention that the breaks in between were artificial. But the labor court found that there were genuine projects. He was being employed in project. Each time he was given an appointment order, termination letter at the end of the project. Therefore, though he had worked from 1978 to 2000 with breaks, the courts came to the conclusion that it was not any artificial break, it was a genuine break, and therefore the employee was not able to succeed in the litigation that has been raised. The next is about probation, whether it will amount to retrenchment when a probationer's employment is put to an end. The contract of employment specifically provided for 1 year of probation. During this course of probation, the employer was not happy with the performance and put an end to the probation. The issue that was raised is that he had worked for 240 days, even though as a probationer, 25 capital F of the ID Act had not been followed, and therefore it would be a violation of the provisions of ID Act, and hence he is entitled to reinstatement with back wages. Supreme Court held that no, terms of employment clearly provided for probationary period. His services had not been confirmed, and therefore the question of 25F would not arise. This is where the employee was again on a contract basis as a weaving trainer. He was considered as a employee, but it was found again the employee's employment was not one where it was only a program-based employment, and therefore 25F would not arise. Under section 200BB, exception under the definition of retrenchment, it's held that it was not retrenchment and the employee would not be entitled to any benefits. This went against the employer, where a large number of people were retrenched. The court found that the seniority was not published and many other procedures that were contemplated were not followed by the employer. More so, first come, last go was not, and it set aside. It's one of the earliest cases on the subject, and therefore we thought, though the law on first come, last go is quite known to all of you, this is one of the earliest judgments on the subject. Moving to the POSH, this more arises out of a repetition of false complaint. The employee per se was not employed by the employer, which is the Rehabilitation Council of India, but was an employee of a third-party contractor. She alleged that the chairman of the council wanted to have a physical relationship. When she refused, her services were terminated and filed a writ petition. Then the court goes into the various aspects and found that first and foremost, she was not an employee of the Rehabilitation Council of India. There were warnings. And only after termination, she comes up with this plea, and therefore the writ petition was not entertained by the High Court. It's a case of a false complaint. We thought we should also try that such kind of false complaints do come about under the POSH Act. The answer to our quiz is no. There's no provision for an employee to waive his or her right for minimum bonus under the Payment of Bonus Act. The complaints calendar for the month of May 24, we would be sharing the PPT and you can have a look at it. Lastly, we wish to inform you that we have been getting requests from our viewers to move to a working day instead of a Saturday evening. So we are shifting our Labor Law Connect to 5 p.m. on the first Thursday of every month. So we will not be having a session in May, but the next session will be on 6th June 2024 at 5 p.m. Please do join us. Thank you.